Wait, how does an elevator at capacity lead to a fight? Seriously, that's a curveball. How does that escalate? Let's see what happens.
In 22 CR 10214B, State of Texas versus Gracie Sugundo.
All right, welcome to the courtroom drama that's about to unfold. Buckle up. You've got the State of Texas versus Gracie Sugundo. We're about to see how this one plays out.
Could I have parties announced for the record for the state?
Daniel Escobar for the State of Texas.
Defense?
Javier Oliva and Bradley Bellis for the defendant.
Are you Gracie Sugundo?
Yes, ma'am.
All right. According to the plea bargaining agreement, punishment is to be assessed at 7 years in the prison. There's a $500 fine. The state is opposing your application for deferred adjudication. They're recommending community supervision, and there are items to be taken in consideration. Have both parties had a chance to review the PSI report?
Yes.
Any objections to the PSI report, state or defense?
Judge, so there are some errors on the PSI report that we wanted to bring to your attention.
Yes.
So it lists the offense date as, I believe, November 16th of 2021, when in reality, the offense date that's on the indictment is October 16th of 2021.
All right.
And it lists that in the criminal history. There's an assault that was in the criminal history that it makes it seem as if they're two separate offense dates.
Okay.
And then I think in the towards the back of the actual statement itself that Ms. Sugundo gave, there's a portion where it's talking about the co-defendant and that he's charged with ag assault deadly weapon. It's assault SBI. It's the same offense.
Okay.
We just wanted to make sure you were aware.
All right. And the court is also in receipt of victim impact statement. And the court reviewed that without objections from the state or defense. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
And the court is also in receipt of letters that defense presented on behalf of the accused. And there were no objections to the court reading those letters. Is that correct, state and defense?
No objection, State Judge.
All right. So the court has reviewed all of those documents.
Your Honor, I also raised that part of the agreement of coming back today was that the misdemeanor occurred on the same day of this alleged date. Was to be taken into consideration of CC County Court 4 case 69-3701.
Yes. And the court does have that as a part of the plea bargaining agreement.
And Judge, just to kind of expand on that, I believe as an additional part of the plea agreement was that she was to take responsibility for what happened as a part of the TIC.
Yes. Okay. All right. So my understanding, the complainant in this case is Rebecca Martinez?
Yes.
All right. And is that the Rebecca Martinez who's on the fourth court?
Yes, Judge.
All right.
President of the courtroom.
Okay, let's pause right here. Did the judge just say he knows the complainant? That's got to add a bit of tension to the air, right? Is this going to be a case where connections could cause some drama? Or will justice reign supreme?
So that everybody can be aware, I do know Rebecca Martinez. She's never been to dinner at my house. I've never been to dinner at her house, but I do know her. We are colleagues. And when I see her, I say hello. She says hello to me. I may ask her about her day. She may ask me about my day. But I will tell you that my decision on this case is not going to be impacted by the fact that I know her. So if anyone has any objections to me hearing this, now is the time to say so. State?
No, Your Honor.
Defense?
Your Honor, I have all the confidence that it was fair and right in this case. So no objection.
All right. So are there any witnesses that anyone wishes to present? State?
So the state doesn't have any witnesses. The main thing that we wanted the court to be aware of was the statement from the complainant, which the court has already noted that they've read.
Yes. Defense, any witnesses?
Your Honor, other than my plea to you and our arguments to you before considering sentencing in this matter, I will be speaking, and Ms. Sugundo may say a couple of words, and Ms. Sugundo's parents are present in support of her today. They can stand with Mr. Standing here in support of her today.
All right. Thank you.
They will not be speaking.
All right. So before I begin with your presentation, with regards to the case to be taken in consideration, if you could raise your right hand for me, please. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right. You can lower your hand, state your name for the record.
Gracie Sugundo.
All right. And with regards to County Court Cause number 6, 93701. The state is taking that case into consideration, but to that case, how do you plead?
Hold up. So we're moving from a no contest plea to a guilty plea? This is like a courtroom plot twist. Also, note the drama. Unfolding. The judge is not playing around with accepting no contest. It's got to be guilty to move forward. Legal maneuvering at its finest.
No contest, sorry. I'm just so nervous.
That's okay. So in order for me to take that into consideration, she will have to accept full responsibility for it. So a no contest plea, I can't accept that because I don't have any police reports in regards to that. So she will have to enter a plea of guilty to it and accept responsibility for it. And then the state will tender dismissal to the court and the court will sign that. I don't know if you want to discuss that with her.
We'll go ahead and proceed with a guilty plea, Your Honor.
All right. So the county court cause number 6933701, how do you plead to that? All right. And state, do you have the dismissal
Yes,
for the
Judge.
court in that cause number? All right. So the court then will hear argument. State, you're opposed to deferred adjudication?
Yes, Your Honor. The reason why the state is opposed is because of the nature of the offense, the actual underlying facts. There was an assault that occurred where the resulting assault it created a lot of issues for the complainant. She was severely injured. Her life was severely impacted from that date forward, and she still feels the impact to this day. It's something that was senseless and didn't need to happen in the first place. So that's why the state is opposing deferred and is asking for probation.
Defense?
Your Honor, we're here because one incident can't define a person for the rest of their life. And this is very serious, and no doubt we take that very seriously. This is a felony charge. It's a felony charge that carries a very significant penalty. But Ms. Sugundo, I think, has demonstrated a respect not only to others, but to life and to animals, and in her work and her career in taking care of pets. Rarely do I have an opportunity to where a client will provide 32 letters of reference about how wonderful she is with caring for others. And that is the life that she defines herself with. We just feel like this should not define her as a felon for the rest of her life when she has 4 children as a single mother. We know that life is difficult and it's very, very, very hard. And she's having to raise 4 children on her own, ages 15, 14, 12, and 10. As a single mother, she has to be involved in her school activities.
Okay, we've got a lot on the table here. 4 kids, a felony charge, and the pressure of being a single mom. That's a lot to balance. Do you think this one incident should define her life? Let me know what you think, because this feels like a case that could really divide opinions.
Support their activities with FAA, and a felon cannot be associated with children and be around them in school activities. This would drastically impair her ability to be a mother to her children. And so she's really fighting to be able to continue to provide the love and the support of 4 children that need their mother so that they can become better than her and have a future. She lives in Houston. She leases a home. She's lived in that home for 3 years. She has good family support. As I've said, her mother and father are present. She has a high school diploma. She has been employed during this whole time. This case is 2 years old. 2 years this week, this happened. And it's been 2 years that she has been experiencing this, and she has complied with everything this court has asked. She's appeared in court. She's traveled from Houston to San Antonio. She has fully cooperated. She has weighed all of her decisions and sought not to seek a trial, but to put the decision on deciding her future on you. And she made that decision because she felt that was in her best interest. She does receive some child support. She is willing to do everything and anything that it takes to give her this opportunity. I explained to her that deferred adjudication is a double-edged sword. You may think like, okay, you're not going to be subject to a conviction, But in actuality, you are subject to all the conditions and behavior.
Wow, the defense is throwing everything in the ring. Anger management, community service, even urine analysis. This is a multi-pronged strategy to avoid a felony conviction. But will the judge bite? That's the real question.
For 7 years. We're asking you, Judge, to give her that chance, to give her the opportunity to prove to you that this one incident does not define her life or who she is or how she is as a mother or how she works. This case was very regrettable, and it should have been a day of celebration. It was after a football game, and she was acting in defense of another. She doesn't know the victim in this case. She doesn't know the judge. She never knew who she was. And I sincerely believe that just because she's a judge doesn't mean that this case should be treated any different than any other case of any other person who comes to this court and gets justice, because she should get an opportunity to do it. She's willing to do the urine analysis. She's willing to state no contact, and she's had no issues in the last 2 years with the defendant, the complainants in this case. She's willing to take anger management classes. She's willing to do community service. She's willing to do what it takes to give her the chance. And she has proven, other than this one incident that happened in a flash, wasn't premeditated, it wasn't thought of. It was just something in a reaction and defense of someone that she was.
Okay, the defense here is trying to emphasize how deeply committed this person is to complying with all conditions. But it's interesting. How can you convince the court you're not a repeat offender when this whole incident happened in such a flash? The speed of it all is almost shocking.
With. And for that reason, we think that she should be given an opportunity to earn the right to be able not to be a convicted felon. The amount of restitution in this case, I think we've agreed to, that was presented before the court, was $2,416.29. We fully agreed to repay that. We will work hard every day to pay that back. But in this working community and in Houston and San Antonio, mothers every day have challenges. And we regret that this happened. And I know that she sincerely had nothing personal against Ms. Martinez.
Here's the judge's take on the situation. He's saying, look, I don't care if you're a judge, the president, or a rock star, you're still just a person in this courtroom. Impartiality here is crucial in maintaining fairness. But real talk, does it ever feel like the system treats people differently based on their positions? Let's discuss in the comments.
For her husband, she wants to do what's right, but she also wants a chance, Judge. And I'm asking you with all the fiber of my body to give her that chance. And I will make sure and work with her that she will comply with every condition, so she will never be back here before you regarding any violation or any condition of this case. You want to say something?
No, yes.
All right. Well, just so you know, in this court, I see everybody as a human being. I don't see them as their titles. So for me, defendants are not defendants. They're human beings who are accused of a crime. The fact that Rebecca Martinez is a judge, that doesn't mean that I'm putting weight on.
Now this elevator fight, a classic case of things spiraling out of control fast. You can't help but wonder, how does a simple misunderstanding about an elevator's weight limit escalate into a brawl? I mean, who really gets that upset over waiting for the next elevator? Was it the alcohol? The tension after a game? We need answers.
The fact that she's a judge. If she were the president of the United States and she were here as a complainant, I wouldn't put weight on the fact that she's the president of the United States. I'm just dealing with the facts here. And my job is to look at everything objectively and not outside noise, not what people's occupations are. You understand? So I always reread everything and reread police reports and the PSI report, and I've read the letters. I do not understand how the fact that an elevator has a limited capacity, how we go from people saying the elevator is full, you cannot be in an elevator, to it's a brawl. So explain that to me.
I mean, it just, I don't know, I couldn't tell you.
I mean, there has to be some sort of thought process. For example, if there's an elevator, I think everybody knows there's a weight capacity on the elevator.
Mhm.
Me personally, when I see there are too many people on the elevator, I don't get on. But obviously what we are here now for is there's an elevator. According to everything that I've read, the elevator was at capacity. And there were already some people on there. I don't understand how an elevator is at capacity. People need to get off or more people can't come on. How that ends up in a fight.
Yeah, I couldn't tell you how it started. I just,
So it turns out the elevator capacity issue wasn't just some petty argument. COVID regulations came into play here. Suddenly, the elevator is no longer just about weight. It's about safety. But the way this all spiraled, who is at fault here? Was the altercation inevitable once people were forced to squeeze in together?
somebody in my party was getting into it and somebody hit me and I just reacted. And unfortunately, I feel bad and should never have done that. Shouldn't have got to that. It just happened really quick.
I know things happen quickly, but the police report I'm reading, it doesn't say that somebody in your party got in an altercation and you got hit and so therefore you got into a fight. What your counsel is telling me is that somebody in your party, I guess, was in a fight and then you decided to get involved in that fight.
I went to go and try and pull my friend away, and then I don't know, it was just a bunch of people and somebody hit me and I just reacted.
Your Honor, if I could clarify, I think the facts is this is a COVID era situation in the elevator. These elevators can accommodate 18, 20, 22 people, and they were limiting it to 7. And as people went into the elevator, the policy and procedures of the elevator operator of not allowing people to come in once they met capacity. They were in the elevator, they were asked that there was too many in the elevator, and then people had to decide who's getting off, and they asked who she was with, another man and another person, to get off the elevator. That person said, I want to talk to your supervisor. That individual entered into an altercation with the victim's husband that spilled out of the elevator onto the floor. She came in assistance to that man, and that's when she was hit, and that's when she struck the victim. That's stated in one of the reports here that was provided to you in the PSI. And she did not go in there to fight. She didn't go in there to look for someone to fight. She was trying to get someone off of her friend. And in the process of that was struck, and she injured Ms. Martinez. And so it's regrettable, Judge. There's no doubt about that. And this incident happened in a matter of seconds. And that's why we're here 2 years later doing that. And in addition to that, Judge, there is a civil suit in this case where the parties in this case are seeking $1 million in damages against my client. And so this case will not end today. It will continue in a civil matter with a lower burden of proof, where she will have to defend herself in a civil cause of action for money damages.
And Judge, just to clarify from the state's end, I would disagree with the characterization of how the incident started. The party was already on the elevator. The complainant's party was already on the elevator. They were asked to not enter the elevator. They weren't kicked off the elevator. They were asked not to enter.
They were in the elevator.
And that's what started it.
And I also have a copy of the lawsuit that was filed this week before the sentencing, where they're seeking $1 million in damages in civil lawsuit right here. If you want to see it, Judge, it's public record.
I would object just because relevance.
It's a lawsuit and filed in the city court. That's a copy from the courthouse.
All right. Unless there are some facts that are listed in the
It pleads
lawsuit.
the whole case, Your Honor. Exactly what you're talking about is pled in the civil suit.
I mean, if that document has facts that somebody has, alleged facts that somebody has presented, that's a different rendition from what's in here, then the court will.
It does not, Judge.
All right. So,
just to let you know, there is a civil suit.
all right, then the objection will be sustained. All right, I've read your letters that were presented, and it appears that
A civil lawsuit? Now this takes things up a notch. With $1 million claim on the line, the stakes here go beyond just criminal charges. And here's the kicker: while this case might end with a sentence today, the real financial battle will continue in courtrooms elsewhere. So, how do you think this will impact the outcome of the criminal case?
other than this one incident, you're a great person. But sometimes sentencing, well, not sometimes, always sentencing has to do with punishment, rehabilitation, and basically whether or not someone should go to prison or not go to prison. These are all things I have to think about. You understand? And so I have to weigh certain things. And the things that I'm weighing are the fact that there were people in the elevator and you were asked not to get on the elevator. Is that correct or is that not correct?
You were on the elevator.
Your Honor, the elevator's doors open. They entered into the elevator and they were asked, there were too many in the elevator, and the elevator operator asked people to voluntarily get off.
All right, so there were already people on the elevator. Then you got on the elevator and you were asked to get out?
Let's just walked in at once.
All right,
And
and then you were asked to leave.
then they said we need people to get on.
All right, so why didn't you just get off the elevator? That's what I don't understand.
True. You didn't decide that.
Yeah.
She didn't decide that. It was a person that she was with, Your Honor, who is a defendant in the case that's in another court.
So my question is though, if there are too many people on the elevator, and let's say you get on the elevator, it's a group of you, the elevator is already filled. I'm assuming, and correct me if I'm wrong.
All right, now we're getting into the punishment versus rehabilitation debate. Sentencing isn't just about what you did, but who you are and what you've done. But in this case, can a single bad decision, one moment of a fight, completely erase a history of good character? Can the past really be judged just by one flash of violence? Let's get into it in the comments below.
People were on the elevator. They had not met their 7-person capacity. And then you and your group come on. And because of the number in your group, they've exceeded their 7-person capacity. And then they're saying, you all need to get off the elevator and wait. Why not just get off the elevator? That's what I don't understand. Even if you're with somebody in your party who says, I'm not getting off the elevator, why didn't you just get off and I'll wait for the next elevator? I'll take the stairs. I don't understand.
We had already gotten off 2-4, so we said like we've been waiting, but we didn't want to be the ones to get out.
And was alcohol involved, or people just don't want to take the
It was after a
stairs?
football game, Judge.
Estate, does anybody want to? I know the complainants are here. Do they want to
No,
say anything to the court?
no, Your Honor.
Okay.
Oh, Your Honor, may I have one moment?
Yes. And then after this, we're going to take up Pete Diaz, Emmanuel Castro, Michael Martinez, Larry Berry, and Michael Moore.
Your Honor, I'm going to call case Martinez.
Okay.
Your Honor, he's not a victim in this case. Why would